start with, I will be referring to Justice Ginsburg interchangeably as Justice Ginsburg, Ruth Bader Ginsburg, and RBG. She's also known as Notorious RBG. And so I want to introduce to you my fellow panelists, each of whom is somewhat notorious in their own right. And I'll start with Dr. Buckley, who is my colleague at U of L as the Paul Weber Endowed Chair of Politics, Science, and Religion. And he is our resident expert on religion and democracy. He's published research that looks at the influence of Pope Francis on US Catholic voters, comparative constitutional law of church-state relations, and the role of religion in the Trump administration foreign policy. So Dr. Buckley is going to talk tonight a bit about the implications of Judge Coney Barrett's nomination to the Supreme Court. Next, we have three amazing alums of the department. I'll start with Amanda Allen, who was one of the first students that I had when I started teaching at U of L. And she graduated summa cum laude from U of L. She studied political science and communication. She left us and went out to California, where she graduated from Berkeley Law School in 2019. And she is currently employed as a law clerk for a federal district court judge. So welcome to Amanda. Next, we have Sarah Pennington, another former student. She graduated from U of L in 2017 with her bachelor's degree in English and political science. As a former English major, I feel a kindred spirit with Sarah. And she is currently pursuing a dual degree, a master's in political science and a JD from the Brandeis School of Law. And she is aiming for a graduation date of spring 2021 and has, I think, some really great experiences to bring to bear here. And then last but not least is Kara Thomas, who I had many, many times as a student, it seems like. She's also a U of L graduate, majored in political science, maybe most importantly, played the role of Ginsburg in our constitutional law moot court, where she dressed the part very convincingly. And she is in her second year at Brandeis School of Law and is currently working as a law clerk at Kentucky Elder Law. So I'm so pleased to have this group here with me tonight to help us kind of discuss the implications of Ginsburg's legacy. So thank you all for joining me. So I want to start by talking about the impact of Ginsburg. And I think you can't really fully understand the importance of what she was able to accomplish without focusing first on her experiences in law school and her early career. And so Ginsburg, and probably many of the people here have seen either the documentary about her life or have seen On the Basis of Sex, the movie that came out later. And so you may be aware, but she was one of only 9 women in her Harvard Law School class of 1959. And if you're interested in what that experience was like, I would recommend to you, and Amanda, if you could find this, I don't have the link off the top of my head, but Dahlia Lithwick, who writes for Slate and has a podcast called Amicus, did a great oral history project where she interviewed Ginsburg and her classmates, or the family members of the classmates if they had passed away, about their experiences being in law school. And it was a very difficult time for these women. And you may be familiar with the anecdote where the women in Ginsburg's law school class were invited to the Harvard, or by the Harvard Law Dean, to his house for dinner. And they thought they were sort of being congratulated, but upon arriving were asked what they were doing taking the spot that could have been awarded to a man. In some of my own work, looking through oral histories of other women who went to law school during this period of time, we find similar kinds of experiences. We find experiences in the law school classroom where women felt belittled by their law school professors, were rarely called on, or were called on only in days when the class was going to cover the topic of rape. So it was a very difficult experience for a lot of students. And for Ginsburg, on top of the pressure of being, as she put it, one of the only ones, right? So when you answer a question in class, all eyes are on you. Like, you feel like you have to represent an answer for all women everywhere. In addition to those challenges, she arrived in law school. She was married. She had a toddler. And so she had to juggle the demands of a very challenging law school with parenthood. And not too long after she arrived at law school, her husband was diagnosed with cancer, and so she had to spend time caring for him. In spite of all of those things, she still managed to make law review. In fact, she was the first woman to make law review at Harvard. And I found a quote from her that talked about this time where she said, "Each part of my life provided respite from the other and gave me a sense of proportion that my classmates lacked." So she really saw her need to juggle work and family as an advantage that helped her manage her time and provide her sort of with a fuller experience. Now, her husband was ahead of her in law school, and so when he finished and was offered a position at a law firm in New York City, she left Harvard and transferred to Columbia Law School. Again, she killed it in the classroom. She made law review, and she graduated first in her class. And so you might think that she had a lot of opportunities when she finished first in her class, but she interviewed at 12 firms, and they all turned her down. And she had a law professor recommend her for a clerkship at the Supreme Court with Justice Felix Frankfurter. And he turned her down, said he was not yet ready for a female law clerk. So she experienced a lot of very overt discrimination early in that time. And even though she is someone who's quite exceptional, that experience of overt discrimination was not exceptional at all for women who were graduating law school during that period. That was quite commonplace. And so she, unable to really find a footing in private practice, ended up in academia. She taught at Rutgers Law School. While she was there, she spearheaded an equal pay campaign for female faculty. She then moved to Columbia Law School. She was the very first woman who was granted tenure at Columbia Law. And she uses those experiences to really inform her sort of the next stage of her career, where she becomes this famous litigator. And that's, I think, where a lot of people are familiar with her impact. And there's a lot of things in her career there that really track the trajectory of Thurgood Marshall in his work with NAACP before he was nominated to the Supreme Court. So Ginsburg goes to the ACLU. She co-founds the Women's Rights Project. And part of, one of the things that if you read, and I would encourage you, the ACLU Women's Rights Project has a really great archive of all the women and men who worked there during this period of time and what it was like. And one of the topics that they focused a lot on was pregnancy discrimination, as this is quite common in the workplace. They were unable to persuade the Supreme Court to address it as a type of sex discrimination. And so the Women's Rights Project was part of the lobbying effort that was able to succeed in passing the Pregnancy Discrimination Act. And it's worthwhile noting that part of what Ginsburg's interest in this was from a very personal experience, because when she had been at Rutgers Law School, she'd had to hide the fact that she was pregnant. And this is, again, very common for women during this period of time, where even law firms would be very straightforward about telling you once you were pregnant, they would fire you. So during her time at the ACLU, she works on many, many cases and ends up being the one who goes and delivers oral arguments in 6 of them before the Supreme Court, which is quite an accomplishment. Most lawyers don't get one. And she had a pretty good track record. She won 5 out of the 6 cases. And in all of these cases, and in many of the other cases where she worked on the briefs or worked on other aspects of the case, the theme kind of behind all of them has to do with the harm that's caused to both men and women when the law relies on gender stereotypes rather than assessments about individual capacity. And so if you see the movie On the Basis of Sex, you see that this is about a provision that actually disadvantaged men. And this is, again, part of her kind of overall legal strategy, particularly appealing to a Supreme Court at this time, which was comprised of entirely male justices. If you're wondering what was the one case that she lost before the Supreme Court, it was Conn versus Shevin, which was a case where the Supreme Court upheld a Florida property tax exemption that was granted to widows, but not to widowers. So the court upheld that. But other than that, she excelled in her arguments before the Supreme Court. So when she arrives as a justice, when President Bill Clinton appoints her to the Supreme Court after her husband goes out and lobbies really hard for her to be considered, if you've ever seen her in any kind of public appearance that's been recorded, you see that she's a very small woman. She comes off as kind of a reserved person. and her husband was unabashedly sort of her biggest fan. And so she ends up being confirmed by a lopsided vote to the Supreme Court, and she serves for 27 years. And during this period of time, what's kind of remarkable is that she has basically perfect attendance at oral arguments through 2018. And this is through 2 bouts with cancer and also the death of her husband. So there was not much that could sort of knock her off her stride. On the court, her legacy among her law clerks, and this is a piece that I want to really emphasize, was that she served this role of teacher and mentor. All of her law clerks who have sort of spoken about her after her passing have emphasized what an amazing writer she was and how she worked with all of them to improve their writing. She requested that every draft that her clerks provided her would be triple spaced so that she would have plenty of room to add her own feedback about what they needed to improve. So she was definitely a very demanding boss, but was also very kind of supportive in her expectations. She worked very hard. She often burned the candle at both ends. So she would be working well into the evening. But she also had, her reputation in the court was also one that I think had a lot of humanity to it. So some of you may be aware that her closest friend in the court was the late Justice Antonin Scalia. If you know anything about his jurisprudence, you will know that they have really nothing in common. But beyond that, the two of them sort of forged this unlikely friendship, in part because they bonded over their love for opera. The two of them both loved to travel. There's a great picture of Justice Ginsburg and Justice Scalia on the back of an elephant that's worthwhile seeing. And there's even an opera written about their unlikely friendship, actually. So Scalia Ginsburg, which I have not seen, but apparently is quite impressive. So she developed this reputation as someone who could extend an olive branch to those that she did not agree with. And her clerks across the board remember her as someone who was there to kind of foster a positive working environment in the chambers. And this is the kind of the last point that I want to make before we open it up into some discussion. So in many prestigious law spaces, and that includes the Supreme Court or law firms or other places, there's not necessarily an acceptance that lawyers have a personal life or that they have families. And rather than having her clerks sort of hide away their family lives and their personal lives, she really embraced and encouraged her clerks' decisions to let that part of their life be visible. So she encouraged them to bring their children into chambers to visit. She encouraged them to go home for a family dinner or to pick up a child who was sick at school or to pick up their child from daycare at the end of the day. And several of her former law clerks who were men talked about how she was supportive of their decision after clerking for her to decide to take a break from law for a while and be a stay-at-home dad. And it seems like maybe that shouldn't be such an accomplishment, but I just want to underscore the fact that that is not a norm that you would necessarily see in other chambers across the Supreme Court. And so showing what it could be possible to be a very successful lawyer and a judge, but also to have a fulfilling personal life, I think is an important part of her legacy, aside from all of the opinions that she wrote and the cases that she argued. So what I'd like to do next is I'd like to start by engaging with our alums, who are all three, so Kara Thomas, Amanda Allen, Sarah Pennington, who are all three at different stages in their legal careers. And Amanda, maybe I'll start with you first. So for you, what are the elements of Ginsburg's life, her story, that resonate with you as someone who is now a lawyer? I can actually say that you're a lawyer now.
Yeah, it still feels very unreal, even though I'm coming up on like my year anniversary of practice. But for me, it's two things about her it's her career and her work ethic and perseverance. What sticks out to me about her life story and her career is that Justice Ginsburg, and as you mentioned in your introduction of her, often was one of the few or one of the only in the room throughout her career. From law school all the way up until even some time on her Supreme Court when Justice O'Connor retired, and she, for a time period before Justice Sotomayor came on the court, was the only woman on the court. But despite that, she persisted and persevered and was successful in her career. And that really resonates with me as a Black woman who's an attorney. And I often find myself, even today, one of the few or one of the only in the room and throughout law school. And I find that really inspiring, that despite that we have some improvements to still make in the legal profession, that you have somebody like Justice Ginsburg, who, despite all the obstacles that were put in her path, still made it to the Supreme Court, still made a difference in people's lives. And then the second part was her work ethic. So she spent, before becoming a judge, as you mentioned, time as a litigator and fighting for particularly women's rights. To be able to do that, I think that, and actually as a lawyer in general, you want to be able to work hard and have an incredible work ethic, but it's particularly important when you're fighting for the rights of others. And I find that really impressive as somebody who also wants to do public service, public interest work in my career.
That's great. Right. Thanks, Amanda. Yeah, I think, one of the things that Ginsburg would often point to in her comments kind of later in life was how many more women are in law school now compared to where it was when she was there. So that was something that I think she was always very, very focused on. So great. Thank you very much. Sarah, what about you? What is it about Ginsburg's career or her approach or her story that resonates with you?
Yeah, thank you, Dr. Moyer. So my first year of law school, I have about a 20-minute commute between my home and the law school. So I listened to her biography. It's written by 2 authorized biographers as well, but it's called My Own Words. And in that book, she really carefully details her relationship with her mother, her husband, Marty, and then with the first female Supreme Court Justice, Sandra Day O'Connor. And kind of, explaining how each of those relationships were really critical to her success. One of the first things that she points out was that her mother, who passed early in her life, always told her to be a lady and to be independent. And she remarks that, the latter was a really unusual message during her time, during her teenage years. And so kind of hinging on that line, I grew up in a really traditional Appalachian community, but my family was different, for a variety of reasons. And I had parents who, just really encouraged me to embrace my potential and to be myself. And our community wasn't necessarily that way. It was very heteronormative, very white, very Southern Baptist. And so, if you were kind of different and you didn't meet the expectations of the community, that often kind of resulted in isolation or even retaliation. And so, that's not to say that, all Appalachian communities are like that, or that's a general criticism of Appalachia, but a lot of people struggle living in communities or, living in certain places where, they face that kind of retaliation or difficulty being themselves. And I think RBG does a good job of explaining how people like parents, teachers, spouses, colleagues are the type of people who can counteract those effects in our life. She also talks about how Marty just lobbied endlessly for her to get on the court, and a lot of times he was integral to her getting positions that she did. And similarly, when she got on the court, it was really Sandra Day O'Connor who kind of showed her the ropes. There's a really sweet moment in the book where she talks about the first time that she read an opinion from the bench, and right before she started to read, Sandra Day O'Connor had a clerk who passed a note to Ruth Bader Ginsburg, kind of empowering her and giving her the confidence, that she needed before she delivered that first opinion. So I think those people were really crucial to her success, and likewise, those people have been really crucial in my life to my success. So that's definitely something that resonates with me.
That's great. That's a great story about O'Connor and Ginsburg. I think it's interesting, and certainly those two women, they're very different women. They have very different backgrounds, but both of them had very similar experiences in law school, had the same kinds of challenges to find jobs, dealt with the same kinds of issues as judges, where you were joining courts where, for example, holiday parties would be held at private clubs that did not admit women as members. And so the women would have to come in the back door. So they both had very, had kind of a shared sense of ambition. And I think that is something that's something that unites them, even though their perspectives on the law were somewhat different, for sure. Yeah. Great. Well, thanks, Sarah. So Kara, let's hear from you. So you're the greenest of the three alums here. And so, but I remember even as an undergrad, you were Ginsburg was someone who meant a lot to you.
Yeah, so I think if I had to put it in like two terms, just her sheer passion and selflessness was part of the reason that I decided to pursue law school. I was never the kind of person who was like, I'm going to go to law school and I'm going to be an attorney. I knew one attorney, and it wasn't a field I was comfortable in up until senior year of high school. I was going to be an oncologist. What a path I've chosen. So, and it was just reading everything after her death. Nita Totenberg did a wonderful piece on her relationship with her, and I listened to that again before today, and it was just her passion for not only what she believed in, her family, her friends, but just women and minorities in general is really important. And coming from someone whose law school class is a majority female class instead of a male class, it's really cool just to see how far we've come and know that when we walk into the room, like, we have come so far in such a relatively short amount of time. And it's because of trailblazers like this. And I work with the elderly and the geriatric now, and it's just seeing how she dedicated her life to giving those who don't necessarily have a voice or didn't have any way to fight for what they believed in. It's really important, just because the people who we're dealing with, most of the times they can't verbalize what they feel. So we have to kind of put the pieces together and hope that what we're doing is what they would want to do. So it's just, she was one of my favorite people, and I'm really honored to talk about her today.
That's great. Well, I want to share, thank you so much. I want to share a couple of comments that I have from former students who are not here, about sort of what she meant to them, since sort of along these lines. One person wrote, when they had heard about her passing, that it was as if I was hearing that a family member had passed. And someone else wrote, her death felt larger than life in a way that I can't explain. Another student wrote that RBG was a formidable force in the legal field, which inspired me to go to law school to follow in her footsteps. Justice Ginsburg protected my rights as a gay man when others would not. For that, I'm very grateful for her fiery dissents and her moving majority opinions. So you can see that her inspiration, goes pretty far and wide. And so I think this is a good space to maybe talk about some of her opinions, some of her noteworthy decisions, some of her dissents. And she's obviously famous for her dissents. That was a later in life thing that she became famous for. So Amanda, is there an opinion from Ginsburg that you find to be, that you really love, or that you find to be really inspiring?
There is, and before I say what opinion it is, it's because for me, it represents how her life work kind of came full circle as a litigator, and then to ending up on the Supreme Court. Especially when you're doing the type of work and like civil rights and dealing with social justice, you don't necessarily see the progress that you want to see at that right moment. It takes time, and Justice Ginsburg's kind of litigation strategy and her thinking about gender discrimination and chipping away at it a little bit at a time. And that is representative of how it takes time, but you're able to use the law to make it happen. So the VMI case, which I'm sure a lot of people are familiar with in that case, is the United States versus Virginia. VMI, the Virginia Military Institute, had a policy of admitting only males. Long story short, the Supreme Court decided that that policy was unconstitutional in violation of the Equal Protection Clause. And in that opinion, Justice Ginsburg actually referred to an opinion that Justice O'Connor wrote. And in that opinion, that case involved a nursing school in Mississippi that only admitted women. And this Supreme Court, and Justice O'Connor's majority opinion, explained why that was in violation of the Equal Protection Clause. And so Justice Ginsburg relied in part on Justice O'Connor's opinion. And Justice O'Connor, in her opinion in this Mississippi case, had drawn on some of the litigation and cases that Justice Ginsburg was involved in as a litigator. And I think it's just a beautiful representation of how her advocacy work kind of came full circle and how it progressed over time. And that is why that's an opinion, and like just the kind of background behind that opinion, how it ties to some of her other work. And Justice O'Connor is why it's particularly inspiring to me, because it just goes to show that progress is slow, but it's possible.
Thank you. Well, and that's such a great case. And I think I just recently learned, actually, after teaching that case for many years, that Chief Justice Rehnquist initially assigned the opinion to O'Connor, and O'Connor refused it and said that it was only right for it to go to Ginsburg because she had dedicated her life to fighting for this. So I think I had not picked up on those connections about how they're kind of citing each other. But you can really see, as you say, you can really see kind of the fruits of her labor like coming into action there. So that's really great. Well, thanks, Amanda. Sarah, what about you? What's an opinion that you find to be resonant?
Yeah, so I actually have pulled an opinion that I read last year during con law, and it had, I remember reading it in class. I remember Professor Powell discussing it, and this really small moment. And again, it's a moment between Justice O'Connor and Justice Ginsburg, but I really thought it was a powerful example of Justice Ginsburg's work and her precision and her accuracy in the way she wrote opinions. And I also thought it was interesting because if I remember correctly from her biography, the justices actually circulate their opinion. So the majority, the concurring, the dissenting opinion amongst each other for weeks before they're released, in sort of this, conversation to develop their own arguments and maybe to possibly kind of win each other over. And so when you read the majority opinions and the concurring and dissenting opinions all together in a case, you really can see this interesting conversation that's going on between the justices. And so the case that really strikes me is Grutter v. Bollinger. It's a 2003 case that's about race-conscious admission policies. And so Sandra Day O'Connor authors the majority opinion, and she concludes the opinion by making this statement: we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interests of proof today. And so essentially in 2003, Justice O'Connor is saying, we've had enough of, this affirmative action. We've, done away with kind of the vestiges of discrimination, so we should stop using these policies that were, that have been used to address that issue in society. So it's this really small concurring opinion. It's not even a dissenting opinion. It's a concurring opinion from Justice Ginsburg and Justice Breyer. And it's literally 2 paragraphs. And at the end of the concurring opinion, Justice Ginsburg jumps in and says, from today's vantage point, one may hope, but not firmly forecast, that over the next generation's span, progress towards non-discrimination and genuinely equal opportunity will make it safe to sunset affirmative action. That's such a small, powerful statement. And especially when you go back to Brown v. Board of Education and you get to the heart of that case wasn't simply about desegregation, but it was about eliminating the badges of inferiority that segregation and slavery had caused. It was about, eliminating the disadvantages that Black students had experienced as a result of the history of the United States. And in that small, sentence, she really strikes at the heart of that and says, equality isn't, just the way society presents itself. It's not surface level, but it's the way, society actually is. And, it's just amazing to me that in such a small statement, she can have this, exchange with Justice O'Connor and make such a powerful point. And, that's just really excellent lawyering. And, sometimes I think we want to think of Ruth Bader Ginsburg as the dissenter. We want to think of her as a litigator. We don't necessarily think of her as, an intellectual, but she really had, this strong, intellectual background. And you can see it in just these small ways. She translates a really big moment into a small sentence.
And it goes to how she really focused on precision in writing, right? She used exactly the words that she needed to use to be able to get that point across.
Absolutely.
It's great. And actually that's not an opinion that I even would have really thought of, but that's such an important case. And it's worth noting, of course, that in kind of thinking about where the court is right now, that Ginsburg was in the majority in the most recent affirmative action decision about, this is Fisher versus University of Texas. And both she and I believe Justice Kennedy were both in the majority. And so both of them are gone. And so that's another area of law where her absence will, I think, probably be felt. So thank you, Sarah. That's a great opinion. And Kara, what about you? Is there an opinion that sticks out to you?
So in the wake of everything that happened, I pulled out all my case briefs and I was trying to figure out where this passion for Ginsburg started. And like Amanda, I immediately went to the VMI case and we're about to read it in my con law class. And I was just going through and trying to understand what that case meant to her, because it was her first opinion on the court. And this was her baby. And just going through and reading it, we have a professor in the law school who tells us that the most important tool you have as a litigator is being able to tell an important story. And you can't forget the individuals who are behind the story. And I feel like a lot of the time when we are advocating for rights and voices and everything, we kind of lump everybody together. And we can tend to forget that we are all just a lone person who's just trying to make our way in the world. And she had a quote in it where she's talking about Virginia's decision on how to accommodate women. And she says, the Commonwealth's great goal is not substantially advanced by women's categorical exclusion and total disregard of their individual merit. So she brings to light just the women aren't qualified just because they're a woman. Like, each woman has their own story. And that was the part that spoke to me. And it reminded me that she is thinking of every woman behind this and not just us as a group of people or as a class. And yeah.
That's a great, I think that's a great quote. And in that opinion, I think one of the things that she emphasizes is that that VMI is not for all men either, right? But that for those who are above average in their abilities, that if this is the kind of challenge that you seek, that this is the kind of institution that men or women could succeed at. And so I think you see a little bit of potentially of herself in there, right? That she knows that she was not the average woman. And so she's paving the way for others who are like her, who are going into spaces that are hostile spaces that have not accommodated women in the past. And so it's a really important decision. And I think, it's interesting. So all of you picked cases where she was in the majority. And of course she has a lot of dissents, as well. And people, one that I would highlight if you aren't familiar with it, is of course, her dissent in the Voting Rights Act case, the Shelby County versus Holder case. And this is the case in which the majority of the Supreme Court invalidated part of the Voting Rights Act that required states who had had a history of voting discrimination to have new voting laws cleared by the federal government before they went into effect. And she wrote this sort of great passage about how the law's effectiveness was basically being used against it, that it's as though you're telling someone to put down their umbrella during a rainstorm because you're dry. And so she has, she has, I think, a really powerful voice. Of course, the Voting Rights Act is something that's in conversation right now as we're thinking about the upcoming election. And so this is an area where I think, her voice is going to live on for a long time. What I'd like to do next is I'd like to pivot just a little bit. God, that's a terrible word. I'm sorry. No one should ever say pivot anymore in a COVID world. But I'd like to think a little bit about, as we are moving forward on the Supreme Court, what does her absence mean? And one thing that I would sort of add about her legacy, we focus a lot on sort of her civil rights work, is also that she, on a court that has been pretty strongly pro-business, that she also was a consistent voice for consumers, for unions, for government regulation. And so her absence in that area will, of course, affect the direction of Supreme Court doctrine too. Right now we're in a space where we have, President Trump has nominated Judge Amy Coney Barrett to replace Ginsburg on the court. And Judge Coney Barrett is already is a sitting federal judge right now. So she's a federal appellate judge in the Seventh Circuit. And political scientists who look at judicial ideology based on her prior decisions estimate that she would roughly sort of be placed between Justice Gorsuch and Justice Alito on the Supreme Court. And for reference, Justice Alito is the second most conservative justice on the Supreme Court. So in a lot of ways, Amy Coney Barrett would be someone who was very similar to her mentor, Justice Scalia. Coney Barrett clerked for Justice Scalia on the Supreme Court. And if she's confirmed, she would also be the sixth Catholic justice on the current court. She would join Roberts, Alito, Thomas, Kavanaugh, and Sotomayor. Justice Gorsuch was raised Catholic, but apparently attends an Episcopal church. And then Justice Breyer and Justice Kagan are both Jewish. And so this is where we're going to direct this question to Dr. Buckley, because I think in terms of considering the significance of this nomination, as someone who's a scholar of religion and American politics and has done a lot of work on Catholicism in particular, what do you think the selection of Coney Barrett says about sort of where we are in this moment?
Yeah, thanks, Dr. Moyer. Thanks for putting this together. It's a pleasure to get to be here and hear from you all and some of our students. So, I think that there are two ways to think about the impact of this potential transition politically. One is in terms of what it means for the court and some of the constitutional law sort of battlegrounds related to religion in different ways. So I'll say a little bit about that, likely impact on the court itself. And then the political stakes, the more short-term political stakes when it comes to the ongoing election campaign, because I do think that that absolutely factored into the decision that the Trump administration made with the nomination of Amy Coney Barrett. Okay, so on the court itself, I think that, as you've already pointed out, this would mean that just numerically we have the largest number of Catholics in history on the court, which would sort of be interesting trivia. I think it's interesting to think about why that is, though, right? It's this interesting, for me anyway, confluence of, I think, the institutions that Catholic legal education has built up over the years, which have provided paths towards sort of fast advancement in the legal profession for both potential Democratic and Republican appointees, right? So we have this really well-trod pipeline at this point in time that conservative Catholic jurists trod, right? That is related to very, very high-profile, accomplished law schools at Catholic universities, probably mostly Notre Dame in that regard, but that also extends into non-Catholic universities that just have traditions of very high achieving Catholics attending. It's related to major conservative legal societies like the Federalist Society. And so it's not just the ideas of these Catholic judges, I think, that have made them attractive nominees. It's also the institutional channels that they have built up over the years. So I think that's sort of just on process interesting to think about. In terms of the substance of court decisions, as many of you know, we've sort of been going through a shift in Supreme Court jurisprudence over the past 25 years or so from a more separationist view of the religion-state relationship to one that is much more open to a lower wall of separation, accommodation, even financial support for different aspects of religious institutions. And Justice Ginsburg, it's fair to say, was someone who was quite concerned that lowering the wall of separation would result in privileging for majorities and exclusion for minorities, and was very sympathetic to religious exemptions for minorities, for instance, in the Holt v. Hobbs case about a Muslim inmate in the Beard accommodation, but was very skeptical of religious exemptions when it came to, from her point of view, majority communities that were imposing potential burdens on others in society via their objections. So the Hobby Lobby decision, the Affordable Care Act. Based on what we know, I would expect a potential Justice Coney Barrett to be exactly the opposite on both counts. She has participated in exemption decisions related to COVID executive orders, for instance, where she has been relatively sympathetic to sort of accommodationist exemption-based claims for religious institutions. She's written publicly in support of religious accommodations for the Affordable Care Act that needed to go, in her view, beyond what the Obama administration offered. And so I would expect that this would be another vote on that side of exemption cases that are likely to come up. In terms of establishment, I would suspect that school funding types of decisions that come before the court in various ways would be things that she would be relatively sympathetic to, in keeping with the drift of conservative jurisprudence since the Zellman decision about school vouchers that had sort of incidental, that had effects on religious schools that, of course, Justice Ginsburg dissented from, right? So I think that's the sort of legal likely implications. It's not a new trend. This trend towards accommodation has been going on for a couple of decades now, but this would really, I think, cement that trend for a significant amount of time. On the political side, if I could just briefly say, I really do think that this is a political decision in part made by the president to try to solidify his white Christian coalition. It's worth noting that exit polls indicate that President Trump's coalition in 2016 was roughly 73% white Christian, right? In some way. Now, it's not white Catholics, but it's white evangelicals, white mainline Protestants, white Catholics, and Mormons. And he wins the white Catholic vote quite convincingly. The overall Catholic vote is evenly split, but he wins the white Catholic vote quite convincingly. And so I think that one of the goals with this appointment is to try to solidify his standing with the white Catholic electorate. And, I've seen some people who have argued that this is a sort of, the mechanism would be because of abortion, basically, that she's somebody who's likely to overturn or further restrict abortion access. And so white evangelicals and white Catholics will like that, and that's why they'll be enthusiastic about this. I actually don't know that I quite buy that mechanism, because if you look at sort of survey research, at least among white Catholics, the abortion issue is rarely a super salient issue. There is a sort of small core for which that's the case, but it's not a super salient issue, and it's also not an issue on which Catholics are as conservative as white evangelicals are. So I actually think that the model, the effect that Trump is hoping to have on the white Catholic electorate is much more of almost an ethnic model, where he sort of is seen as pushing back against an era of fading white Christian influence in American life. Scholar Robbie Jones, who won the Grawemeyer Award in religion the last time we gave it out, has this great book called The End of White Christian America, where he talks about how the fading of white Christianity's dominance in this country is sort of shaping conservative politics. And I think that this fits within that, the sense of kind of a fading minority that needs representation, and therefore she serves a representational role as a white Catholic. And this is why I think, for instance, the confrontation that she had with Senator Feinstein actually is exactly what Trump has in mind. He wants that to happen, right? He wants Democrats to give his supporters any reason to feel aggrieved and looked down on. And he would be more than happy if the doctrine living loudly within her was a major theme of her confirmation hearings. I think I don't expect that to be the case, because I suspect that the Biden campaign will try to get the word out that they would like some alternative messaging this time around. So a little bit on the court side, a little bit on the politics side. I think it's an important transition, and one that's likely to have a lasting impact.
That's great. Thank you, Dave. That was fascinating. That's really great. And I think, there probably are, we can continue to talk all night about this, but I'm sure that there are folks who have questions. And Amanda, I know you have some from folks who had submitted them before the session started. And so, I don't know, do you just want to throw out one or two?
Yeah, sure. So someone asked how RBG has changed your views on discrimination.
Maybe that's a good one for our alums. What do you think?
I'll go ahead and start out, Dr. Moore, if you'd like me to.
Sure.
So I want to reference back to that Grutter v. Bollinger decision, and also kind of want to, again, talk about Ruth Bader Ginsburg as this intellectual figure, in addition to, her figure as a litigator and a Supreme Court justice. One thing that I think is really interesting is that you learn about if you look at her litigation. We talk so much about how Ruth Bader Ginsburg was good at winning people over and building alliances in kind of a congenial, amicable way. But she also, had this really powerful theoretical background, and also this really, powerful kind of litigation background. And so when she's litigating her cases with the ACLU, and one thing to keep in mind too is that she taught civil procedure when she was a law school professor. And so everyone knows civil procedure is an incredibly difficult class, and it honestly doesn't make sense even when you're out doing actual civil procedure. So in the process of one of the cases that she's litigating with the ACLU, and I don't think she wins this case, but in the process of discovery, one of the state's attorney generals that she's, opposing counsel with, has to turn over a list of laws that discriminate on the basis of sex. And so this is huge for her, because it creates kind of this target list of laws that the ACLU can now go forward and start to challenge. And so, that is really a testament to Ruth Bader Ginsburg, and how she, thought about these things and was able to accomplish a lot of her work. And I also want to talk a little bit about, the Grutter v. Bollinger case, and the way that she would address discrimination as something, especially sex discrimination, as something that affected both genders. And that's very much a way to get people to think about sex discrimination, when oftentimes when we approach people and we talk about sex discrimination, race discrimination, those things, they get defensive about it. It's difficult to have those conversations. But if we can address them in a more neutral way, if we can talk about the ways that sex discrimination affects both sexes, it kind of starts those theoretical turnings, and it starts to make people think and, change the opinion in a way that they're not resistant to it. They're more willing to think about it, and they're more willing to have a different opinion. At the same time, I think it's important to not just see RBG as someone who wanted to, I think it's important to make sure that we don't have kind of a shallow understanding of her theoretical approach to discrimination. Because even though that was the mechanism for, convincing people to change their opinions about discrimination, her jurisprudence is still really powerful in understanding that discrimination isn't something that just exists in a single moment, but it's a process that, continues to have lasting effects. And, even today, Ruth Bader Ginsburg remarked that women going into the legal field, they're not necessarily going into a profession that welcomes them. And this is in an era where we have, groups that support women's rights. We have committees and law firms that are there for women's rights. There are mothers groups, all kinds of things. And there are still, challenges and barriers. So, one thing about my perspective is certainly studying her in law school is that it wasn't just about kind of this theory of creating both of the sexes equally. She also had really sophisticated understandings of discrimination and wanted to kind of strike at the heart of, we're not going to eradicate invidious discrimination unless we eradicate its effects.
That's great. That's well said, Sarah.
Thank you.
Does anybody else want to weigh in? Amanda, Kara?
I was just going to add on to that her approach to legal strategy when she was a litigator at the ACLU's Women's Rights Project, I think is important to note that she was also building on the work of, as you mentioned in her introduction, the likes of Justice Marshall, who was a litigator also before he became on the Supreme Court, but focusing on the civil rights of Black people, and how with both of with racial discrimination and gender discrimination, how it's important, what I've taken from her and the work that she's built off of, how it's important to pay attention to the legal strategy behind people who are doing this work.
That's great. That's great. Thanks, Kara. Do you have anything you want to chime in on?
I just want to echo what everybody said, and I think what hit me most once we heard of her passing was just the magnitude of people and the manner in which she was able to explain such an abstract concept to so many people in a manner that people who aren't in the legal field can understand. So when the news came out, my cousin, who is a dietitian, called me, and she was in tears, and it was just, we were trying to go over what this meant for everybody and what this would mean going forward. And it was really interesting to hear an outside perspective, just because the legal field is very secluded and we talk to each other. And if you don't know legalese, unfortunately, sometimes you get left behind. But Ginsburg did a remarkable job of explaining it in a way that regardless of what background you came from, you understood what was happening and her reasoning as to why it was wrong legally. And I think that's a really important point to make. Additionally, her strategy of taking sex-based discrimination cases against men was a phenomenal tool to kind of turn the foundation of discrimination on its back and just show that a traditionally represented population was the one who was in turn being discriminated against, and use that as her vehicle to pave the way for future cases. And the Moritz case is the one that comes to mind, but just kind of seeing how she was able to just look at it in such a different way that most other people just wouldn't look at something like that. It's remarkable, and it's really something that I think we're going to have to continue to work at. I do have friends who, we're two L's, but they have experienced sex discrimination and harassment at work, and it's not something that's going to go away anytime soon unless we do things and figure out legally, socially, culturally how to address the problems. And I think beginning to talk about them in manners like this is really going to help us reiterate the importance of equality and figure out how to achieve it.
Thank you, Kara.
So I'm gonna, we got a couple of people who asked a similar kind of question, more on the political side. So what are your thoughts on expanding the number of justices or term limits for justices? And why are Democratic leaders, such as Vice President Biden, reluctant to suggest expanding the court if the Trump administration is able to seat a new justice? And I'll let you guys figure out who wants to take that political one.
I would be happy to take that one. I think that sort of on the question about court packing, I mean, for some context, the Supreme Court has, the Constitution does not dictate the size of the Supreme Court. So that is left up to Congress in Article 3 of the Constitution. And the Supreme Court has had quite a range of number of justices. So it started off with 6, then it inched up to 7, 8, 9. We were at 10 for a while, then it went back to 9, and it's been 9 through the modern era, but the number has changed over time. And the suggestion of packing the court to achieve sort of a perceived political advantage is also not a new suggestion. Most people are familiar with FDR's court packing plan, which was, it should be stated that he didn't, the way that it was pitched was that we were trying to take the burden off geriatric justices. It wasn't really about political advantage in the way that we're talking about it in 2020. But this was also a proposal that was floated during on the Taney court, where you had Republicans who were concerned about the fate of Reconstruction, who proposed all kinds of things, including abolishing the Supreme Court and creating a new court because they were unhappy with the decisions. So we've had a lot of these proposals kind of throughout history. But I think that although there is some appeal politically in a short-term sense to expand the court so that the Democrats would have a majority, I do have some concerns about what that would do to the legitimacy of the court. And I think we can go back to Federalist 78, where Hamilton writes that, you know, it's neither force nor will, but judgment. That's what the court has. And the court cannot enforce its own decisions. And certainly the court has become more polarized in recent years. But I would put out there that it's polarized because the justices are a product of the political environment that selects them. So that is, as the parties have become more polarized, so has the way that confirmation hearings and the selection process has become more polarized. And so I think that in a situation where we are fluctuating wildly between president to president in terms of the number of seats, that could potentially undermine the ability of the court to play the role that we've become used to it playing in American democracy. And so to the sort of the second part of the question, Amanda, that you raised about term limits, I think that there are a number of proposals out there that would potentially create more stability for the court. It may not be ideal to have people in their upper 80s deciding the most important constitutional questions all the time. We've had incidents on the court in the past where you've had justices who are clearly in the throes of dementia, who don't want to leave the court for a variety of reasons. And so, you know, I think that it would require a constitutional amendment, of course, but the idea of giving each president a set number of justices so that every president would know that they would have the ability to name 2 justices to the Supreme Court, for example, would take the temperature down somewhat and potentially, I think, reverse some of the trends that we have seen. I think that there's a lot of folks who are institutionalists who are concerned about the desire to achieve political gain. And I think because of Biden's long time in the Senate, I think that's probably part of his consideration now. I also think he recognizes that this is a controversial proposal and maybe you don't want to throw that out before the election that you support it. So we would have to see if he was ultimately successful. And so Dr. Buckley, you might have some sort of perspective on the institutions.
No, not, I mean, I agree that I would generally see Biden as an institutionalist, and I think that would be what I would expect him to behave in that way. Also, I did note, I made it to the end of the debate last night, so I get to actually say something substantive, amazingly enough. This is a substantive point that came out of watching the debate. Biden was willing to punch to his left a number of times during the debate, right? He sort of elbowed the Green New Deal, he elbowed defund the police. But when there was an attempt to pin him down on packing the court or eliminating the filibuster, he actually did not choose to sort of clearly distance himself from that. Now, I don't know how much to read into that and all the chaos that was going on. But again, he was willing to throw some punches to the left on some of the other opportunities that he was given. And on that one, he didn't actually. But I tend to agree that I would expect that he would be most interested in the reforms that could most easily be framed as about preserving the institution's integrity, preserving its functioning, right? And a little bit less interested in the ones that are most easily framed as just kind of partisan advantage.
Yeah. I would add one more thing too, just to whoever asked the question, is that an option that Congress does have available to it, and certainly members of Congress have over the years introduced many bills to this effect, which is that Congress can control the Supreme Court's appellate jurisdiction. And so that means that it has the ability to decide what cases can make it to the Supreme Court on appeal. And so, I mean, we've seen this. It's in sort of the post-war era, it's come more from the Republican side, where you've seen proposals to remove things like school busing, desegregation decisions, school prayer, same-sex marriage, even appeals from Guantanamo Bay. So those kinds of things, bringing those things out of the court's appellate jurisdiction. Congress, if we had unified government, could very easily include abortion in that list, include other things in that list. So there could be things that could be done before reaching sort of the more extreme options that have been discussed.
Any of the other people want to comment on that, or do you want me to move to the next question?
I guess you can maybe move to the next question.
Okay. So we have a question in the Q&A little chat box. This question focuses more on the future of the court. Do you foresee that Judge or would-be Justice Coney Barrett recusing herself from a case should an election deciding case make its way to the court? And what implications of her decision would that have on the legitimacy of the court? I see this as one of the stronger, less politically polarized arguments in favor of delaying a confirmation hearing. General thoughts from anyone?
That's great. So for one, justices don't have to recuse themselves. On the Supreme Court, they have quite a lot of latitude to decide when they are conflicted and when they're not conflicted. So this would be entirely a decision that would be up to her. But, you know, my instinct is that John Roberts, as Chief Justice, has kind of assumed as much of a mantle of an institutionalist on the Supreme Court as we have right now. And that in terms of how he's handled some of the cases from the court decided kind of in the past term, for example, siding with Ginsburg on the census case, there's been some other examples. My sense is that they're looking to avoid something that would be explosive. And so as a freshman justice on the court, we might very well see that she would be counseled that it would be wise for her to step aside. You know, Justice Gorsuch and Justice Kavanaugh got right in there. So, you know, certainly she could do that if she decided she wanted to. But I think that there's no question, and I think Allison's right, that there would be a real concern about the appearance of impropriety and potentially some institutional damage to the court, particularly if her confirmation is expedited in such a way that she's on the court ready to decide after Election Day. I'm interested in what other people think about that, but that's my take.
Yeah, I mean, I don't really know, honestly. It's hard to predict sort of behavior, obviously, because there's not going to be much constraint once she would be confirmed. All that I can think is that one of the incidences from his first term that I am sure that President Trump most regrets is not getting Jeff Sessions to promise that he wouldn't recuse himself from the Russia investigation before he nominated him. And I'm not saying that there would have been any direct promise made in this regard that your nomination is contingent on you promising me that you're not going to recuse yourself. But I mean, the president has already framed this nomination in terms of potentially deciding the election. And so I don't know that, I mean, I wouldn't at all be surprised if there were conversations that were had about what's your view on the potential role of a hypothetical justice in that period. I don't know.
Yeah. I suspect we will hear about this some during the confirmation hearing.
I've got another question I'm going to kind of mash together a couple of people to ask some similar things. And I've really enjoyed hearing from our alums their thoughts about how Ruth Bader Ginsburg has affected them personally. And so as you're familiar with other court decisions, the question is how the federal court composition has changed since her appointment years ago, and then whether there's anyone that you all are following, I guess, probably on the federal court who's up and coming, who has a potential to be as impactful as she has been.
Wow, those are some big shoes. I mean, I can speak to the first part of the question for sure, in that the judiciary has changed quite a bit since she was on the court. And we now have, on the federal appellate side, we've got courts that have a majority of judges who are not white men, and that did not exist. It really did not exist when she came onto the court. There were very few women. But it really does vary region by region. So there are some places, some circuits within the United States that have a lot more racial, ethnic, and gender diversity, and others that are still kind of predominantly white and male. And so certainly one of the spaces that President Trump has made a big impact is in judicial confirmations. And his nominees have been overwhelmingly white and male, though he has named many more Asian judges to the bench than previous presidents. So that has been a space that it has been affected sort of within the past 3.5 years. But I don't know about the successor to RBG. Amanda, are there any good lawyers that you all are seeing come before you?
I honestly can't think of any off the top of my head. That's a big question, but I can't wait to see who that ends up being, like as far as like a lawyer who has the kind of like a future judge who has the same kind of like celebrity and just impact in the public.
Yeah. Great question. Whoever asked it, we're all stumped.
Does anybody else have a question and want to just raise your hand? I've got a couple more in the that were pre-submitted, but in case there's anybody here who I wanted to kind of go back and forth. I don't actually, okay. So
I think we have one, Amanda.
Okay.
So I think, so Paul, I see your hand is up.
Oh. Hold on, I may have to fix that. Paul, is that working for you? No. Okay, I don't think he was able to chat, so we may have to. Oh, he said he doesn't have a question.
Okay.
Thank goodness.
So I guess this one's a little more in the political realm as well. But should we be concerned? And maybe we've covered a little bit, but should we be concerned that the nominee would undo all of the work that Ginsburg has done while on the court?
Sarah?
Yeah, I'll jump in on this question. This is something that I really thought about in kind of the past, since RBG has passed away, because obviously there's a lot of anxiety in addition to grief over her death. But I think one of the things that we have to think about in terms of a new justice coming onto the court, that it's not, just about justice's personal opinion. Obviously, like, that's incredibly influential. Justices are not going to depart from whatever personal ideology they have to an extreme amount, but there is, kind of a degree of legal gymnastics that justices do have to go through in order to make judicial opinions align with whatever personal ideology they hold. And so something I think that is really on people's minds right now is Roe v. Wade. And I think something important to know about Roe v. Wade is that, obviously a woman's right to an abortion is not explicitly in the Constitution. And they actually infer that right from what's called a penumbra, this idea that the Constitution casts a shadow and that there are certain things that are implicit in that shadow. And one of those things is the right to privacy. And so from the right to privacy, we get the woman's right to choose. And even in Roe v. Wade, that, or the case that followed, well, I'm confusing myself a little bit here, but Roe v. Wade over time has changed, and not in terms of the woman's right to choose, but on the burden of scrutiny that we place on a woman's right to choose and regulations that might be issued in addition to that. So kind of taking that into thought, you know, there's a lot of legal theory there that a justice is going to have to go back and work through. And like I said before, the court kind of has its own internal mechanisms. They have conversations with each other through their opinions. The court obviously has its own practices in terms of having a freshman justice and in terms of their participation or what opinions they're going to get assigned. So, you know, the ability of a new nominee to come in and immediately start attacking this, you know, judicial legacy, I think it's a little bit more unrealistic than we necessarily think it is, because there is kind of a degree of work that has to be done there. And, you know, I don't know if you have more on that, Dr. Moyer, but that's just something that I've been thinking about these past couple of days.
Yeah, and I think, you know, about abortion in particular, I mean, I think it's worthwhile noting that the court has moved in a much more, as you noted, a much more conservative direction on Roe since since 1973. And so the right to an abortion is actually quite constrained today. And there's not really necessarily a need to overturn Roe versus Wade. The court could continue to restrict that right more and more. And, you know, we did see the court strike down a law this term, though there's some question about whether that precedent is really sort of robust enough to go forward. So I agree with Sarah that I think this will be more of a long-term kind of shift, but I am interested in some of the cases that Dr. Buckley mentioned. The court had been sort of going in this direction on religious liberty. With the departure of Justice Kennedy, we were sort of left hanging because he had a line of cases about LGBT rights that seemed to suggest a lot of protection, and he had a line of cases on religious liberty. And so we have cases like the Masterpiece Cakes case with the wedding cake baker, where these two things are kind of seem to be coming into conflict, and he never really resolved that before he retired from the court. And so that project has been left to other justices, and I suspect that like her mentor, Judge Coney Barrett would not be someone who would be very sympathetic to sort of Kennedy's perspective on these things. Certainly Scalia was no fan of it. So I see religious liberty as an area where I think we will see the court potentially accelerate the trends that have already been there.
Yeah, no, I mean, I think that's exactly the way to put it. It's a trend that's already been going on, but I think it's going to continue. I will say, I think there could be some issues that are now on the table in religion and law that haven't been on the table in quite some time. So school prayer, for instance, is one, you know, as many of you know better than me, constitutional law about religion is kind of a mess, right? But actually, if there was one relatively coherent area where there had been some consistency in the past 20 years or so, school prayer was one of these areas where the court had tended to sort of hold the line from the separationist era in the 70s. And, you know, there may be votes now there to reevaluate not some of the classic school prayer decisions, but some of the gray area decisions about voluntary prayer at sporting and graduations and those sorts of things that haven't really been on the table, but that might now be back.
Yeah, I think so too.
We've got another question in the Q&A that's just a really lovely question. She's wondering if anyone could comment on what gave RBG her ability to be so generous, gracious, and hopeful in the face of so many challenges. Besides these mentors that Sarah referred to, did she draw on religious commitments or other philosophies for inspiration?
That's a great question. So Amanda or Kara, do you all want to weigh in, or Sarah? I'm happy to, but.
So Sarah mentioned earlier Ruth Ginsburg's relationship with her mother. And if you have a chance, just please read My Own Words. It's a beautiful testament to who she is as a person. And I really do think it helped my 53-year-old father try to understand how she thought through everything she did and the justifications behind that. And the lady comment that her mother made, I really think that kind of inspired her and was her life motto, just because she never said that she had to be a lady in the normal sense of a word, where she was the breadwinner, or she was the mother at home and the housewife. She didn't know how to use an oven until, I believe, Marty's passing, right up until Marty's passing. And so I think that just really challenges this traditional notion of she was this small, petite woman and she was gorgeous and she did all these things, but she said that she never, being a woman to her never meant putting her in this cage. And she was always taught to take her life to the fullest and pursue whatever passion she had. And so I think that was one that was really one of her most close mentors. Another one I'm going to mention again, Nina Totenberg. I didn't realize how close they were until she passed. And Nina did an expose on her relationship, and it's about 10 minutes on NPR's website. So that's another really, really phenomenal piece on just her relationship with other women and with other people. And she took a lot of time to just listen to people, and you never felt like you were talking to the celebrity RBG, like you were just talking to a really cool little old lady. So I think it's just really important for us to remember she's really easy to make a celebrity, and for good reason. She's a phenomenal person. I think we're lucky to have lived in the same time that she did. But at the end of the day, she was a person. She made mistakes and she owned up to them. And it was just the relationship she had. She let them influence her and forge her will and her passion. And it's something that we could all learn from.
Great. I will second the Nina Totenberg comment, because I listened to that story as well. It was really touching. And I would add to that, if you watch, and C-SPAN has all of the coverage of the memorial, the rabbi's comments when she lied in repose at the Supreme Court, and also the comments when she lied in state at the US Capitol. Of course, she made history because she was not only the first woman to lie in state, she was also the first Jewish person to lie in state. And so, talking about what it means to live a righteous life, I think that's a connection, with her Jewish faith.
Yeah. I mean, I think that's absolutely important to note. And it's she was a representative of a long tradition of sort of Jewish intellectual leadership on questions of civil rights and the law. And so we don't first think of her as a Jewish justice, and I think that's probably appropriate, but I think it was absolutely central to her own self-image, and also the role that she saw her jurisprudence play in building a just world.
I remember reading a quote from her recently, and I don't remember the exact words, but basically the gist of it was that she wanted to leave the world better than what she found it. And to get a JD and have the ability to practice law is an incredible privilege. And I think that what drove her is, in part, is that be able to use that privilege of having a law degree to help improve the world and leave it to the better. She didn't just go off and be a lawyer. And she talks about how, had she not faced the difficulties that she faced, her and Justice O'Connor may have retired as partners of a law firm. Nobody would have maybe ever heard of them. But because she believed in doing work that would better the world in the end, I think that also was something that was a philosophy that influenced her work.
Great.
And just echoing what Amanda said, and then going back to the My Own Words book that Kara brought up, and a quick plug for Justice Brandeis. One of the people that Justice Ginsburg describes in her book is Justice Brandeis. And so what we learn in law school and what other people may know is that Brandeis was called the people's lawyer. And he took so many pro bono cases in his practice that he ended up actually owing money back to his law firm for work that he did on these kind of public service cases. And, since they had a common kinship in their Jewish religion, she wrote a lot about him, a lot about his work. And it's clear that, as her predecessor, that he had an impact on how she viewed the law and she viewed her role in the law. in terms of helping people. So
That's great. Brandeis appreciates you, Sarah.
exactly. If you want to see his papers, we have them at our law school. You can schedule a tour post-COVID.
That's great. Well, I think we're kind of getting to the end of our time. And I know that Amanda wanted to pop in and say something, but I want to thank all of the panelists and all of you for being here and asking great questions, and also giving us a chance to have a little bit of a moment to reflect and to celebrate. The news cycle moves quick these days, so sometimes it's nice to pause and take stock. And so I'm grateful that we had a chance to do that tonight. I think everybody sort of needs that these days. So I want to thank everybody for being part of this event.